Ladies and gentlemen, welcome to today's treatise, which is the 10th. Our topic for today shall be forceful evictions by government, a Habinger for poverty, gross violation of human rights, and chaos. Now, today's treatise has been informed by happenings in our country. Basically, I'm talking of forced evictions that we are all aware has been prevalent in our country's major cities. The latest one being the one around 3 days ago at Kariobangi North, where around 5,000 Kenyans were rendered homeless after being evicted from what they have known as their homes and places of businesses for so many years. Apparently, the eviction was carried out by the Nairobi City Water and Sewerage Company, which claims ownership of the same. We are also aware that the same forced evictions were also experienced sometimes in Kibra. I think it must have been in July 2018 when the Kenya Urban Road Authority carried out evictions from what was said to be, a part of what was expected to be public land meant for public road within the informal settlement. And of course, to date, no compensation has been done to the affected persons. Of course, the Nairobi County government has also joined this game, and we are all aware of the what happened in July 2019 in Pangani, when persons or other people were evicted from their homes. In fact, this one took place at midnight, and your guess is as good as mine. There has been no compensation whatsoever insofar as that is concerned. Of course, Kisumu County has also not been left out, and we are aware of what happened in around August 2019 when, pursuant to a notice of around 1 month, persons were evicted from what they had known as their places of businesses for around some as far as 20 years, in lands that belonged to the Kenya Railways. And of course, these evictions were meant to create space for the revitalization, expansion, and most principally, operation of the Kisumu Inland Port. Now, of course, you do realize that the core of these evictions from public land is basically meant to enable the our governments, both national, county, and as well as their agencies, to carry out what would amount to be the big picture in terms of economic development, be it like in the case of Kariobangi, to ensure and that citizens are provided with clean and safe water. In the case of Kisumu, to transform the inland port. But the issue that we intend to address today is, to what extent must the government go in ensuring the big picture? To what extent must it go to compromise what would otherwise be described as the fundamental human rights of its people? Now, it is important to note that forced evictions are, have been addressed within the international setup, and in this case, I have in mind the certain international conventions in which Kenya is a signatory to, and therefore pursuant to Article 2, Sub-Article 6 of our Constitution, they form part and parcel of our laws. And which conventions do I have in mind? I'm talking of the Universal Convention on Human Rights, 1948. I also have in mind the International Covenant on Economic, Social, and Cultural Rights, particularly at Article 11. And what is critical, what is important is that, these conventions at ISWA appreciate forced evictions to be, such scenarios that arise when when governmental agencies purport to uproot citizens or people who find themselves in what would otherwise be public land, but without proper documentation or rightful authority that would otherwise enable them to occupy such lands legally. Yeah. Now, the issue is that the international conventions, and I have in mind the International Covenant on Economic, Social, and Cultural Rights, has addressed this question of forced evictions. In fact, you will be surprised that actually in 1977, a committee issued a general comment to the effect of, to the fact that, it created certain thresholds, certain guidelines that ought to be followed when you carry out such evictions. And these guidelines, amongst others, are that before you carry out such evictions, you must involve the affected parties. This brings in that aspect of public participation, which is also a requisite as per our Article 10 of the Constitution. Yeah? It also emphasizes that there must be adequate and, reasonable notice to the person so that, they can then have time to seek legal redress or alternatives for those who are able. It also envisages that the individuals must be informed of the project that that is occasioning their eviction. What is it that the government intends to do, and such that they get to appreciate the public interest, which is even to their own benefit, so that they own the process and they don't take it like they're being victimized. It also envisages that in carrying out such evictions, if need be, the same must not be carried out, where there is bad weather or at night, contrary to, what is happening in certain instances in our country. In fact, at a time when we are aware we are facing the COVID pandemic, how dare you carry that sort of, a forced eviction, so such that you now expose around 5,000 people. So you find that those are cardinals which those are actions which these particular guidelines frown on. It also states, and that is most important, that even as the government carries out such forced evictions, you must guard against and ensure that such evictions must not result in compromising other fundamental human rights of these persons. And you find that is critical. Why? Because, for example, in the Kariobangi case, you are rendering these people homeless, so that by your single action you have already breached Article 43 in terms of affordable housing, which the government is in any case under duty to ensure they provide. But even before doing that, you already rendered your people homeless. So you find that such forced evictions by governments that have got the net effect of causing, alternative breaches of fundamental rights are essentially frowned on by, that particular guideline. And finally, the guideline was such that it recommended that before you carry out such forced eviction, the government ought to create a provision for alternative housing, for cushioning of losses. For example, before you evict, would it not be proper that, put up alternative housing, alternative shelters first? If you are talking of places of doing businesses, would it not be proper that, in the intervening period of the notice, that the government perhaps comes up with, alternative business premises, so that by the end of the notice, what you shall simply do is to relocate these people from where they are to the alternative place, such that, their lifestyles are not all that much, ruffled up, so that you realize that these are a series of guidelines that, this international covenant has crafted, and the gist is so that even if you carry out a forced eviction, it's done in a humane fashion. Yeah. Now, the next question I know, which is paramount, is what do Kenyan laws say insofar as forced evictions are concerned? Now, the Kenyan law would be found in the Government Lands Act, CAP, Government Lands Act of 2012. Now, you'd realize that this is a statute that basically consolidated all the so many statutes touching on land that we had previously. But more fundamentally, insofar as the topic, today's topic is concerned, at section 155, right, it would seem that, or rather that is the position, that the Act vests authority in terms of, making a determination as to if a forced eviction ought to be carried out or not in respect of public land. That authority is vested on the National Land Commission, such that it is the Commission which is expected to issue a notice. The notice ought to be of at least 60 days. That notice would amount to a notice to show cause to the affected parties. The affected parties would then be expected to give a response. The NLC would then be expected to, amongst others, travel through the information and even establish if, in the circumstances, would it be proper to even give compensation. Of course, it is also expected, amongst others, in arriving at a decision, to consider such factors as, for how long have these individuals been in this particular land? Is it such that they are here together with dependents? To what extent would be the effect, what would be the effect of, such eviction on the lifestyle, the normal life of this particular person? So you realize that these are things which the framers of the Act anticipated would be properly addressed by the National Land Commission. And I dare think that, that is for good reason, because you also realize that in its operations, in carrying out its investigatory and, role, and even when hearing their cases, the NLC operates in an ad hoc fashion. In other words, not like the normal courts that are, replete with a lot of technicalities and fashion of doing things, such that it makes it easier for, the citizens and the people to participate through the giving of memorandum and, even just speak out without so much formalities. And then the commission would then, exercise its discretion to come up to a decision, such that what is interesting insofar as the Kenyan instances that we have mentioned, that is the instances in respect of forced evictions, is the fact that you realize that such evictions are carried out direct by the relevant entities which claim these lands. In Nairobi, you're talking of Nairobi Water Company. In Kisumu, we were talking of the Kenya Railways. In the other one in Kibra, we were talking of Kenya Roads Authority. And one would therefore ask the question, where is the National Land Commission that has been tasked both by the Constitution and as well as the Land Act 2012 to deal with the management of public land and to some extent even to deal with the aspect of evictions? Why is the National Land Commission out of the picture? Is it proper that entities such as, or other governmental entities such as county governments, or for that matter county governments, parastatals, is it proper that they can then usurp the constitutionally and statutorily enshrined powers of the National Land Commission to move for forceful evictions? Such that I think this is one question that we really need to address. And we have to appreciate that there is a reason why an entity such as the NLC was tasked with such responsibilities. We must bear in mind that the framers of our constitution were well aware that one of the chapters that was so contentious was the chapter on land. For those who may forget, the 2008 post-election violence in Kenya is said to even have been, engineered because of historical land issues, so that the NLC was crafted and given this mandate, bearing in mind and knowing so well that even in some of these public lands that, controversial public lands that we are talking about, the ownership of the persons that you are finding in those lands was legitimized by a corrupt process that may have been initiated by a public officer in the government, maybe during some years back. And governments ordinarily operate under the principle of perpetual succession, such that a wrong by a government official in lands maybe 30 years ago will still be owned by the government, the current government, and it is such that you cannot then purport to, as it were, incriminate and to harm an innocent citizen who finds himself now in that particular land pursuant to documentations that were presented by the government 10 or 20 years ago. You see, it is on the understanding of that corrupt history within our land system that the National Land Commission was crafted to handle some of these delicate issues, and it was allowed to do that through an ad hoc fashion, and in fact it was also given investigatory powers, such that I do honestly believe that in scenarios such as this on forced evictions, we ought to hear the position of the National Land Commission. The National Land Commission must come out and give directions. They must take charge. We must respect our constitution. We must respect our laws. Now, finally, and now in summation, let me say that it would seem that the culture of forced evictions, as we have had in Kenya so far, is one that is frowned on as per the international covenants, as I have stated. It is one that is not clearly addressed by the government Lands Act, that is our local act, at least insofar as the question of alternative resettlement is concerned. Yeah? And I think that this is one area that really needs to be clearly captured, yeah? Either by way of an amendment of our Land Act, so that a proper framework is crafted in terms of dealing with lands which are occupied by persons who have papers and documents which in any case are questionable by virtue of historical mistakes in terms of registrations of such particular lands in favor of these particular affected parties. I also tend to think that we really need to relook the practice of forced evictions, yeah? Especially when we bear in mind that the persons that are most affected happen to be those that fall within the lower cadre of our society, yeah? And not just that, yeah? Forced evictions also have got that consequence of ruffling and interfering with business setups that have been ingeniously and through innovation crafted by these persons that we are talking of, and who should these are businesses that ordinarily ought to be incubated by the government so that they grow to the next level, and yet in pursuit of our major projects, the multi-billion shilling projects, we always end up having the same shrugged off and just as it were crushed. In fact, it is important, and I want to remind the audience that one of the most successful companies that we have in the world today, Microsoft, yeah, was started sometimes in 1975 in a place called Habinger in New Mexico, United States. It was started in a garage that could only house 2 persons, yeah, and that was by Bill Gates and his friend Paul Allen, yeah. And look at the behemoth that this small enterprise has grown to as we speak today, yeah. In other words, my point is that even as we look at the big picture, even as we try to attract, big business and enterprises, let us not do it at the expense of the small enterprises that we have. Yeah. Let us not do it at the expense of the Juakali enterprises. Yeah. Because these are persons who have innovatively identified local problems and are already trying to get a solution. So that what the government ought to do is to encourage such enterprises so that they move into the next level. For those who have listened at our treatise on how China made it to how it is today, you realize we said that the secret that China did was that it gave impetus, it gave more, encouragement in terms of economic incentives to small enterprises that were at the village, and it is these small enterprises that then moved to the next level of mass production and are currently the manufacturing, giants that we hear of left, right, and center. So that I would say with conviction that the question of forced evictions is one that has to be seriously, fundamentally relooked. And if it has to be done, then we must have proper mechanisms in terms of resettlement and compensation, so that the affected persons, the affected people, in as much as their life will be ruffled, but it should be in a manageable way, so that it should not then be seen that by purporting to promote one aspect of human rights in terms of economic development, we again end up compromising another aspect in terms of the right to life, right to proper and adequate shelter. We are saying that that mismatch must not be countenanced, because a failure to do that, then the consequence would be that the people who have the social contract with the government may then realize and believe that the social contract is not even necessary. Yeah? If the government that is meant to protect you, if the same government is the one that can, let you stay homeless and in the middle of the night with the children in the cold, then that may lead to the expiry of the social contract, and the consequences may be chaos. The consequences may be an unexpected revolution. So I would urge our leadership from the bottom of my heart that let us incorporate human rights principles, yeah, which are clearly captured in our constitution. They are also in international covenants, which as a country we are signatory. And if we do that, then of course all shall be well for the country. Thank you.